Scott and White Health et al. Counsel, make your appearances.
This is Adam Simmons. I represent defendant Baylor Scott and White Health and Scott and White Healthcare.
Jennifer Cheek on behalf of defendant Door Control Services.
Sally Metcalf on behalf of the plaintiff, Jerry Bostic.
Todd Clement on behalf of the plaintiff, Jerry Bostic.
Joshua J. Bannon on behalf of Overhead Door, along with Ruben Gandia and Horton Automatics Division of Overhead Door.
So we're here on a motion to transfer venue and a determination of whether or not Dallas is a venue of proper jurisdiction. So why don't we go ahead and proceed?
Your Honor, Adam Simmons for Baylor Scott and White. This is a case, you are familiar with it a little bit based on some of the facts in our previous motion to quash hearing, but just as a recap, this is a second lawsuit with pretty much identical parties and causes of action. The first lawsuit was filed by plaintiff Mr. Boswick in Travis County against all the same defendants. In that Travis County lawsuit, that first lawsuit, Baylor Scott and White filed a motion to transfer venue. In that motion, Baylor Scott and White acknowledged that it had a principal office in Bell County, and all the events took place. This is a slip and fall, took place in Marble Falls in Burnett County. So everything that happened there, that's where plaintiff was treated. That's where the slip and fall happened. That's where the subject door is. Baylor Scott and White urged the court to transfer to Burnett County. Before that motion was heard in the Travis County court, plaintiff non-suited the case and refiled the same case in Dallas County, which is before you today. And as the court will note in the briefing that we provided, there's Supreme Court case law that prohibits or at least restricts this type of forum shopping that plaintiffs are attempting to do. And the preeminent case on this is Geochem. And in that case, Geochem, similar facts, but plaintiff had filed suit in Dallas County. And I have the PowerPoint, if that's easier to follow along with. I attached it as Exhibit A to my reply brief, and it's the slides that you've seen before in the motion to quash hearing. And in the Geochem case, the plaintiff filed suit in Dallas against the defendants who acknowledged they were residents of Stevens and Van Zant County. And when plaintiff non-suited the case from Dallas and refiled in Van Zant, the court analyzed that and said, well, the state of the record at the time, which is crucial, the state of the record said Van Zant and Stevens were proper. So when plaintiff refiled in Van Zant, it was within proper venue practices. Now, this case is different because in this case, when plaintiff filed in Travis County, the only two counties that were, quote, taken as true became established were Burnett and Bell County. And when plaintiff refiled in Dallas County, Dallas was never mentioned in the first lawsuit. It was not a part of the state of the record under that analysis. And so plaintiffs are attempting this argument to say, well, because Geochem just looked at the state of the record and it just said, okay, just those were true, but you could really file anywhere else, completely ignores the analysis that Geochem went through. Under plaintiff's theory, it would do away with the entire Geochem analysis and say, you can file wherever you want. You can refile as long as that subsequent venue is proper. And if that was truly the rule, then the court in Geochem could have simply said, well, because you've refiled in Stevens County, because that was proper, you're good to go, and we don't even need any more analysis. But the court didn't do that. The court went through this state of the record analysis. And in those set of facts and circumstances, it worked for the plaintiff in Geochem, but the same does not hold true in this case because Dallas County was never mentioned in the first motion of transfer of venue. And this sort of forum shopping has been prohibited in Texas in several cases, and I noted a case, Team Rocket, that was a Supreme Court case heard after the Geokim case, and it went through lots of admonishments of is disallowed and constantly frowned upon by the Texas Supreme Court. And I know the court had mentioned in its previous, well, maybe because Baylor Scott and White had mentioned some other principal offices for some other defendants, like in Nueces, Van Zant, some of these other counties, that maybe it could transfer the case to those other counties. And unfortunately,
let me just clarify that. I think what I said is that if you guys agreed, I could transfer, but I wasn't going to transfer without an agreement.
okay. And that's where I wanted to go, because I wasn't sure if I know you had inquired about it, and because the parties could not agree, I'm here to tell you that the Supreme Court does not allow the court on its own motion nor the plaintiff to transfer to a second choice. So the only place that this court should transfer is to Burnett County, which is what defendant Baylor Scott and White requests. I know one of the door companies also requests Denton County, but those are the only two counties before this court where this venue action can be transferred.
Either needs to stay in Dallas or go to Denton or Burnett.
Correct, Your Honor. And obviously my briefing has outlined as a matter of law why it should go to Burnett, and then also just logistically and convenience wise, everything lines up to be in Burnett County. The plaintiff resides there, the doctors, the nurses, the hospital, the site visit. If people want to go see the site where this potentially problematic door caused the accident, as plaintiff alleges, everything lines up in Burnett County. Nothing matches in Dallas County. And so just for the convenience of the parties, it just makes sense to be in Burnett County. And I would note that the court, if you transfer based on convenience matters or really any matter, because we have a convenience request out there, you cannot be overturned. It's not reversible error. And so whether you decide as a matter of law or whether you decide to transfer out of convenience, you won't be overturned on this, and it will not be reversible error. I have probably some other things, but I'll let plaintiff respond, and I would urge the court to obviously follow up and review the briefing that I've provided in my reply brief.
Response?
Yes, Your Honor. Can you hear me?
I can.
Okay, great. I think we have a disagreement about the holding of Geochem, and I did prepare a chart, but I'm unable to share my screen, so I'm not sure.
Oh, let me allow you to do that. Anyway, I should have. And Mr. Simmons, if you need to share your screen at some point, you're welcome to as well.
Thank
So,
you.
Ms. Metcalf, explain to me why Dallas is a county of proper jurisdiction.
Well, yes, Your Honor. We had alleged that was actually the principal office of Baylor Scott and White, and that is why we should hold venue in Dallas County. Since that time, and this was attached to our reply, Baylor Scott and White has stipulated that for purposes of this lawsuit, their principal office is in Dallas County. So that kind of negates some of the arguments that there is no principal office in Dallas County because there's a stipulation as such.
So let's go ahead and how do you distinguish Geochem and its progeny?
Well, what happened, Your Honor, is in Geochem, the court said you've got to look at the state of the record as true at the time of the non-suit. And we don't disagree with that, Your Honor. If you look at our briefing and if you look at the facts that were alleged at that time, Burnett is a county of proper venue. Van Zant is a county of proper venue. Dallas would be a county of proper venue. We don't dispute that they are counties of proper venue, but they are not the only county of proper venue. So we do dispute Mr. Simmons' allegation that Burnett is the only county of proper venue. And the Texas Supreme Court has held that where a plaintiff files suit in a county of proper venue, it is reversible error to transfer venue under 15.063, even if the county of transfer would be proper if originally chosen by the plaintiff. So I respectfully disagree with Mr. Simmons that nothing that he's alleged would result in a reversible error, because here plaintiffs have filed suit in Dallas County. Defendant Baylor Scott and White has stipulated they have a principal office in Dallas County. That meets the requirements of the Civil Practice and Remedies Code provisions regarding venue. As far as the geochem case, the geochem case, if you look at the facts that were pled at the time of the non-suit, there were several counties listed of proper venue. They listed Bell, Denton, Van Zant, Williamson, Nueces. Now they've stipulated that for purposes of this lawsuit, it's Dallas and not Bell. But there's nothing in the geochem opinion that states that you must rely on only those counties, that those are your only options, what they have listed. We agree that, and you can take that as true, those counties are counties of proper venue if you look at principal offices, but so is Dallas County. And in geochem, the court, let me see if I can share the screen now. Let's see. I wasn't able to pull my documents over prior. Let me see if I can find this, Your Honor.
Any luck?
Here is, let me see if I can do this one. Are you seeing anything?
We're seeing a Sally Metcalf has started screen sharing, but it's black.
Yeah.
Okay, let me look here. Well, Your Honor, what I would point you to, and let me see if I can stop this now so it's not distracting. The geochem decision held, the Supreme Court held that the venue statutes do not say plaintiff may choose venue only once. They simply say that if the county chosen is not proper, the case must be transferred if a sufficient motion is filed and ruled upon. Here, as the parties have all agreed, there was no hearing, there was no ruling on the motion. The Supreme Court in geochem also said that a plaintiff does not lose the ability to non-suit and refile in a county of proper venue. The court held that when geochem filed its second suit in Van Zant County, it did so in full compliance and within the mandates of the venue statutes. Geochem did not lose the right to choose between two counties in which mandatory venue was proper by filing its first suit in a county in which venue was improper. We have filed suit in Dallas County in full compliance of the venue rules. And defendant has confirmed our venue choice is in compliance with CPRC provisions regarding venue by its stipulation. There is nothing in the geochem rule that says that the plaintiff is limited to only the venue proceedings or only the venue counties that defendant listed. And again, we're not arguing that those are not counties of proper venue. They just are not the only counties of proper venue. Defendant also cites the Team Rocket decision, and that has a whole host of different facts. In that case, the plaintiff filed suit in one county. There was a venue hearing. The court ruled that the transfer should occur. And then the plaintiff non-suited and tried to file in another county. And the court said, Supreme Court said, you can't do that. And we would agree with that, Your Honor. If we have a venue ruling, we can't then non-suit and refile in another county. but that's not the facts of this case. As defendant has stipulated, it has an office in Dallas County. We would request that this court maintain this case in Dallas County in accordance with the Civil Practice and Remedies Code venue provisions.
All right, did anybody else want to say anything?
Yes, Your Honor, this is Joshua J. Bennett on behalf of the Overhead Door Company entities. So I think we've got two issues here, and I don't think the plaintiff has quite responded to the full breadth of issues on the second point. One is, was venue proper to begin with? I don't think the court needs to spend much time on that issue. It's really the latter second piece of the motion that we've joined, which is, what's the most convenient forum? In a multi-defendant case like this, we all have to be concerned with defendants who may settle out, whose witnesses may or may not be available for trial, depending on who still remains in the case by the time of trial. And so as Overhead Door, we're concerned with that issue and where the most convenient forum is to try this case. And we think it is Burnett County, given that's where it happened, where the witnesses are. You know, we're probably going to need non-party testimony at some point to talk about, you know, the door itself, its operation, whether Baylor, Scott and White had notice of the door, these kinds of, you know, the alleged defect, all of these things. And non-party witnesses in and around Burnett County are probably going to figure pretty prominently in that. So I think what we're nervous about is,
And maybe
we put it even in,
was it you that filed that said this should be in Denton County?
well, I think what we said, we didn't file any particular motion. We filed a joinder that said, we're fine with Denton. It's hard for us to protest too loudly if the venue's in our own backyard. So we would be okay with Denton, but I think Burnett makes the most sense. And so that's the position we would take. Burnett, certainly. Denton, okay, we can accept that and live with that. But Burnett seems to be the county best suited for a trial, to preserve most of the trial evidence, because the alternative is, as a defendant who's got to try a case, I'm probably going to be presenting an overwhelming amount of videotape depositions rather than live trial witnesses. And that's not a desirable outcome for us. We'd rather have people in the courtroom in front of a jury. Now, all that said, that remains to be seen whether in current circumstances, those kinds of things will still happen.
Yeah,
But with that caveat, we support a transfer to Burnett. Doesn't matter whether it was properly filed in Dallas or not, given the location of corporations. It seems to me an ancillary point at this point. Really, it's a question of convenience. That was one of the grounds raised, certainly by Baylor, Scott and White, and one that we joined. And we think the most convenient forum is Burnett.
Your Honor, if I may respond to that momentarily, if I might.
sure.
So we all know that under Texas law, the plaintiff's choice of forum is to be given great weight, and the convenience of the parties has to be something extraordinary. And I think the court's on record, as are most Dallas courts on record, saying, you know, Dallas being a hub for both for transportation, et cetera, that, you know, we're not going to be transferring cases out of Dallas County on these types of arguments. We all know in today's day and age, many trials are pretty much video trials. And I think it's going to just get more and more. And also, if we'll notice, I think most of the lawyers here are all from Dallas. I think Ms. Metcalf is probably the one farthest away. And so ultimately, I do not think the FNC grounds here are anywhere near sufficient to merit transfer. And I certainly believe that, you know, we can all invoke in these troubled times argument, but we all know that this case is not going to be tried for probably 2 years or longer because of the backlog of 6 months. In 2 years, if we do not have a vaccine that's going to basically put people back into normal patterns, we've got a lot more problems than a case filed in Dallas County that it's more convenient to be in Burnett County. And so I just don't see that being an overwhelming argument that would merit transfer of this case at this time.
Okay, I appreciate everyone's argument. It was very well briefed.
Your Honor, may I have a quick rebuttal real quick on?
Sure, absolutely.
You know, I want to respond initially to the geochem deal, because I believe that to be, you know, probably the crux of this thing. I know plaintiff is basically kind of reiterated, and this is where the tug and pull, and I want to be clear on this because plaintiff is saying nothing in geochem says you were limited to the counties alleged in the motion to transfer venue. And, and my position is no, geochem actually does lock you in. It does lock you in, and it's not just, oh, these are fine, but you can list off a whole, you can refile wherever you want as long as it's proper later on. Because of geochem, under plaintiff's analysis, the whole opinion becomes pointless. And the whole analysis and the entire opinion going through the state of the record analysis doesn't make sense. If the plaintiff can file a suit in his first action and subsequently refile in any venue he chooses, as long as it's also proper, then there was no need to look at the state of the record analysis in geochem. In geochem, the court could have easily held the plaintiff's decision to refile in his second suit in Stevens County was proper venue, and then just left it at that. There was no need to look at the state of the record analysis. And instead, the court created this lock in place. Those venue facts are established, and you can't go beyond that. And I think that's where we disagree. And to me, I just think if you really read the geochem analysis and take it as in its whole, it makes sense that it's locked in, and you can't just say, okay, well, if Baylor Scott & White has a principal office in all these other locations, we can just file wherever. It just doesn't. The state of the record analysis is pointless and moot. And so that's my position on that. I would say I'm also in my office is also in Austin, and so it's not just Ms. Metcalf. I don't know where everybody else is located, but Baylor Scott & White, we counsel for there will be in Austin as well, and that's where Ms. Metcalf is. So.
All right, I don't want to. Anybody else want to say anything before I rule?
Your Honor, this is Jennifer Cheek on behalf of Door Control Services. I just want to reiterate what Mr. Simmons said, that the geochem case actually deals with a case that involves a non-suit that was filed before the ruling on the motion to transfer venue. And we would echo that Burnett County is the proper county.
Okay, anyone else?
And Your Honor, the only thing that I would add that, again, we did not, it is a different situation, I think, if we were alleging that, or if Mr. Simmons had alleged in his pleading that the only county that is proper is Burnett County. And that's not what was alleged in the initial motion for in the initial motion for transfer of venue. Because then we would have had to have filed an objection stating, no, that's not correct. What he did state is Burnett's proper, Bell's proper, and Denton's proper, Van Zant's proper. All these are proper as principal offices. And interestingly, what I think can't be lost is Baylor Scott & White has now come back and said, well, for this case, Dallas is proper. And that's important, I think, because in their initial pleading, they said it was Bell County. Well, if they're now coming back and saying, well, it's not Bell, it's Dallas County for this case, that is a proper county of venue. And I would leave it at that. Thank you, Your Honor.
Your Honor, just one quick follow-up with that. The only reason, obviously, we had a stipulation, and part of the stipulation for Dallas County was to avoid the deposition testimony. I mean, that's really, it's not like we're changing positions and saying, oh God, Bell, we don't believe we're there. It was to say, let's focus on the matter of law, the geochem issue, and the convenience argument, and let's just focus on that and not waste everybody else's time with principal office testimony.
Okay, I'm going to go ahead and rule now. I thought everyone made a great argument, and the briefing was very good. And I agree, this is a tough call because of geochem. I'm not 100. I don't think this really fits right in with where geochem is either. So I'm going to go ahead and deny the motion to transfer, find that venue is proper in Dallas County, and that and that's my ruling. So if you guys could get me an order on that. Do we have a trial setting on this case yet?
We do not, Your Honor.
when do you want to, I mean, Mr. Clements is right. I don't know when we're going to start trying cases. When would you like to set this? Maybe next summer?
I think that's certainly fine. We can all work together. I'm hopeful and select a date looking at your available dates.
I'd like to go ahead and set it now. So let's pick a date. You want to shoot for maybe next June?
Your Honor, I know next June, it seems like everything is already booking up these days. Next June, I show that we are full, but I do show that we are available in May and July. And
Okay. Do you want to shoot for July?
That would be overhead doors preference, July or later. Yes, Your Honor.
As well as door control services, because our May is already booked.
What about Ms. Metcalf and Mr. Clement? How does July look?
I'm okay if it's like the 12th, Your Honor. The last 2 weeks, a lot of times we're on vacation. That's usually the 2 weeks we leave, so if there is anything like a vacation next year. So the week of the 12th is open to me.
Ms. Metcalf, how does the 12th look?
That's agreeable to us, Your Honor.
All right, so we're going to go ahead and set this for trial, Rhonda, on July 12th. And who did we want to use as a mediator?
If we're going to be in Dallas County, the default for most of us in Dallas County is always Mark Gilbert. So if anybody has that, that would certainly be a good choice, I would think.
Mark Gilbert's an excellent mediator, one of the best in town. So, but if there's, what about the defendants? What do y'all feel? You guys like Mark Gilbert?
Mark would be our request as well.
Oh, good.
I would probably need to check with my client, but you know, I'm sure we could work through that. If there is a problem, we could work through that amongst us internally.
And just so it's clear, Ms. Cheek, you said that Mark Gilbert was your suggestion as well?
That was going to be my suggestion, Your Honor.
Okay, let's go ahead and appoint Mark Gilbert. If there needs to be a motion to substitute mediator later, that's fine. I would warn you that he gets very popular, and so don't wait till the last minute to schedule with him. And all right, anything else, guys?
Not at this time, Your Honor.
Not at this time, Your Honor.
No.
Okay. All right, guys, thank you so much. And again, great job with the argument and the briefing. I do agree it's a close call. So thank you so much. You guys have a safe week, okay?
Thank
Thanks,
you, Your
Judge.
Honor.
Thank you. All right, do we have both counsel here on Huffmaster versus Autoflex? I could have sworn I saw Mr. Pitzner and Mr. Williams here. Mr. Pitzner, can you turn on your video, or at least turn on your sound? And Mr. Williams, can you turn on your sound as well?
Your Honor, my apologies. I had my speaker on mute. Benton Williams here, Your Honor, on behalf of Autoflex.
And Mr. Pitzner is here, but he's muted. Mr. Pitzner, will you unmute, please? Mr. Pitzner? Mr. Williams, do you have his cell phone number? Maybe you could text them or call his office.
I do have his cell phone number, Your Honor. I could, whichever you would like for me to do.
Can you just text him that he needs to unmute? We need to figure out what we're doing with this case.
Yes, sir. If I may use my cell phone in front of the court, Your Honor, if that's okay.
That's fine.
Mr. Pitzner, you just need to unmute your device, please, at the request of the court. Well, Mr. Pitzner, if I just ask that you unmute We're here in front of Judge Hoffman. He's waiting for you to unmute your device. Thank you. There's a microphone. You'll see a red dash through the middle of it, and you just click that. Why don't you test that for the court? One more time. No. Okay, I will report that to the court, and we'll try and reach you on your cell phone through the court. Thank you. Your Honor, on behalf of my colleague on the other side, I apologize for the inconvenience. I have Mr. Counsel's cellular phone number if the court has access to a phone that he could.
Well, why don't you call him
reach
on your speaker? Mr. Williams, why don't you call Mr. Williams? Why don't you call him, put him on your speaker, and see if we can hear him. If not, then we'll just do a phone conference.
Okay.
Let's see if it doesn't work, we'll just do a phone conference.
Hello, Brendan.
Mr. Pitzner, you have the court and myself on the line. Can you hear us?
Okay.
Your Honor, can the court hear?
I can kind of, but let's just see how it goes. So, Mr. Pitzner, I understand that there was possibly a bankruptcy filed, and I just wanted to get a feel for, and Mr. Williams, have you looked into that?
Yes, there was a bankruptcy filed.
Okay. Mr. Williams, have you verified that?
Yes, Your Honor. I'm having some difficulty. Is the court hearing a loud noise?
Yes, I am.
Can you hear me better?
Would it be more appropriate, Your Honor, to conduct this?
Yeah, Rhonda, can you go ahead and just set up a phone conference with the two of them, and so we can just talk this out? Did you hear me, Rhonda?
Yes, I'll call him now.
Okay. So Mr. Williams, she'll just give you a call, and Mr. Pitzner, interns, the next hearing, we had a 3:30 that's canceled, and one of our 4 o'clocks is canceled, but the other 4 o'clock, which should be a pretty good hearing, is still going on. So you guys are welcome to listen in while I'm talking to Mr. Pitzner and Mr. Williams. But that's kind of what we have for the rest of today. And Rhonda, do we still have any trials for tomorrow?
Yes, we do. I'll go through and count them as soon as I get through calling the other two attorneys. I think I have to disconnect with you now, Judge. I'm sorry.
That's all right.
Okay.
I'm going to turn off YouTube.